Greetings. Welcome everybody. And we're getting ready to start up records and record keeping from American Jurisprudence. And today we're going over public record laws and crimes. This is part 3, but this is the part we're going to actually be getting right into the meat of it. The first 2 parts were just to get a general look at how the federal courts, state courts, various ways of interpreting public records, their definitions, where they apply, who's responsible for them. We looked at a bit distinctions between things like expungement and cancellation of documents or otherwise removing them, and the differences between them for both criminal records and other kinds. But today we're going to get into the depths of what's really required. So we're going to be getting into the laws for the removal or destruction of public records. And we're also going to be looking into Black's Law Dictionary, 9th edition. Get this ready to go here. Try our best at our Latin too. But yeah, we're going to be using 9th edition because along the way we're going to come across words that maybe not that we don't know, but that might have a specific definition that we want to make sure that we're using the proper one for the laws that we're reading. So let's get right to it. And if you have any questions or anything like that, please let me know in the chat. I'll be monitoring the chat, so we can always add questions, comments, or pause for any more detail if need be. Okay, just making sure everything's here. Yep, we're all good. And please hit the like upon entry so we know there's people here in the room, and let's get started. So, we're starting here with Section 11, the laws for removal or destruction of public records, generally. So the removal or destruction of public records may be accomplished as provided by statute, under statutory terms and conditions, as on the proper and qualifying petition of the person affected thereby. So the removal or destruction of a public record can be accomplished by provisions within a statute. So we'll look to the statute to find the provisions in statutory terms and conditions as on the proper and qualifying petition of the person affected thereby. Now, we say person, it doesn't necessarily mean a man or a woman. This could be any other statutory definition of person. And is not authorized for persons falling outside the statutory parameters, as I said, or records falling outside the statutory parameters. So, of course, the removal or destruction of public records can only be accomplished by statutes that provide for the specific records and authorizing the people within their parameters of the statute. So we'll find the statute both the people responsible for the destruction, the proper qualifying petition of the person, and how they provide for doing it. So let's look here. Caution. One of the beauties of American jurisprudence is that we get these nice little precautions and practice tips throughout, which gives us some real rubber meets the road applications for this theoretical law that we're also learning. Again, this is just for disclosure here. This is purely for educational purposes here. I'm not giving law advice, nor have I got any kind of legal education to give anybody. So don't take any of this as legal advice of any nature. Don't try this at home. This is just for an exploratory educational journey into American jurisprudence and its application today. Okay, so the caution. The authority of a court to order the destruction of public records is not inherent when not necessary for the efficient and effective functioning of the court. So this is a caution. So The authority of a court to order the destruction of a public record is not inherent when it's not necessary for the efficient and effective functioning of the court. So the only way the court can have an inherent authority, built-in authority to order the destruction of a public record outside of these statutory provisions, it would have to be necessary for the efficient and effective functioning of the court. Can't be just for efficiency or effectiveness, but both, because we have and. So again, every word matters in American jurisprudence. So let's continue. All right. So if a record is not a public record, a party cannot be aggrieved by its destruction and thus cannot bring suit for forfeiture under a Public Records Act. So if it's not a public record and it's destroyed, you cannot have any kind of grievance by that destruction, and you cannot bring suit for forfeiture of the record under the Public Records Act. Reminder, the removal or expungement of a public record does not mean the destruction of a record. So, difference, removal or expungement as opposed to destruction of a record. The difference between a removal or expungement means it's not accessible, as in sometimes a sealed case. But the record doesn't disappear. It is still there and accessible should law enforcement or a court need to see it. Destruction of a record is a different nature. So here's our practice tip. Improperly disclosed public records may be subject to an injunction to compel the destruction of the records. So that's an interesting one there too. And this has a reference of 9 on the footnotes, which we could go and look to that case. And we have some cumulative supplements here too, but let's look at case 9 really quick because I'm kind of interested in that. So that was Newark Unified School District versus Superior Court. Oh, great. Yeah, that was in California, huh? And let's see here. Review granted and opinion superseded. Interesting. Publication. All right, so we'd have to read this one up. That looks like complicated. 2016. All right, let's get back to where we were. So the cumulative supplement here, we have a case. So let's read this one here. The term theft, as that term is used in statute, providing a civil cause of action for damages for stolen property, refers solely to theft within the meaning of the criminal theft statute and does not encompass the theft of medical records or medical information under the medical records statute. And thus, no civil claim exists based on a violation of the theft of medical records statute, on a violation of the medical records statute. So this is interesting. 2021, so this is very recent. So you could bet that this would still be established case law at this point, which is another thing about American jurisprudence, that you could check some of the old volumes to find some of the basic interpretations we see up here, but the newer editions as they come out, and I guess that's the only real nice advantage of the digital one, besides having to have huge volume books to store, is that you have these updates that come periodically. Let's continue here. So, trial judge acted within the discretion by temporarily preventing destruction of potentially relevant evidence through grant of firearms applicant's emergency motion to temporarily prevent Department of Law Enforcement from destroying records otherwise subject to statute governing destruction of department records and applicant's action against the department seeking redress for delays in processing of applications. Records may have shown basis for the department's delays, or mindset, or intent of staff or officials involved in decision-making processes. Had the court denied requests, potentially relevant records would have been destroyed without anyone having seen and reviewed them, and the applicants waived privacy rights in relevant information by affirmatively seeking records related to their own applications. And this was in the great state of Florida, 1st District, 2021. So as you can see, this stuff is ongoing right now. And this is kind of the essence of our common law, although these cases really in common law shouldn't be set at this point in time with stuff like this. But as you can see, whenever there's overstep by some of these departments, the redress is in the courts. So let us continue. So we're on to federal crimes for the removal, destruction, or falsification of public records. Oh, we've got a question here. I'll read this out because it didn't look like it all fit on the screen here. But we have, so with an expungement approved for a public intoxication years ago and having a legal gun, then the feds can open and still hold you with a felony conviction if they search your home. I don't know about that, but an expungement approved means that they could still reference those documents should there be a need for it that they can prove. That's the only thing about expungement. Destruction of records is a whole different matter and a different nature of that. So there's a different process involved with that. So that would be the difference there. Again, record sealed and expungement is not the same as destruction of a record. And typically a record can only be destroyed for very certain purposes. Usually what we found in one of the previous ones was one valid reason for destroying a public record is that if it was invalid at the time it was recorded. That is one basis for destruction. Otherwise, expungement is usually retained just so they could see the process of how it got there. Any errors are retained too in the record that led to that. So that is one consideration I believe that from time to time might come into play. So all right, thanks for that question. All right, let's move along. So federal statute makes it a crime to conceal, remove, mutilate, or falsify a record deposited with a United States office or officer. Okay, so we're looking at federal crimes, and we're talking about United States federal and not United. So this is, the Federal Corporation of the United States. So a federal statute makes it a crime to conceal. So concealing a record deposited with the United States office or officer, removal of, mutilation of, or falsifying a record as already deposited with a United States office or officer, and that's under footnote 1. So we're referring to 18 U.S.C. section 2071. Thus, a Merit Systems Protection Board could properly find that the backdating of replacement medical records and an attempt to pass off these replacements as original documents constituted a falsification of medical records under the statute because the consultation sheets that the defendant produced were knowingly false with respect to both the date and the physician's signature, and the defendant used them in a willful attempt to deceive a third party in order to protect himself. So that's a good case to look at. That's number 2. That's Gibson versus Veterans Administration, 1982. And that's in the D.C. Circuit. Of course, federal. Okay, let's continue here. Practice tip. These are always great. The amount of loss attributable to a defendant's unlawful concealment, removal, and mutilation of government records under the statute for sentencing purposes is not limited to the nominal value of the sheets of paper actually destroyed by the defendant. Ah, that's interesting, huh? The nominal value. So there's going to have some other type of value to it besides just the nominal value of the record itself. It would be some type of intangible value, perhaps, for the loss. Good. And that comes from footnote 3, which is referring to this case here. So 1995, U.S. versus Gottfried, the D.C. Circuit. So that's interesting to look at. Okay, let's continue here. So these practice tips are really good. If you have a case that would actually involve something like this, and you get these practice tips, this brings you on the cutting edge of law practice, really. And I wonder how many students fresh out of law school actually spend the time like this great audience does tonight to go through this and really learn the foundations of the real strength of our nation, which is American jurisprudence. All right, let's continue. Another federal statute makes it a crime to knowingly embezzle, steal, purloin. What does purloin mean? This is a good one for Black's Law to look up. Give me 1 second here. I can look it up a little bit faster. The first time is always a little bit of a particular for me here to get it going. But once we get it going the first time, it'll move faster. So we're looking at purloin. Oh, come on. I'm typing it wrong. Okay, so it's not not a legal term here. Well, if anyone wants to look that up, I don't have another dictionary handy, and it's not in Black's as far as I can find here. Nope. No, it's not. Double checking here, so I don't want to leave this cold. C, P. Purloin. Yeah, it's going to be, I don't think it's in here. I don't think it's a legal term, but this is one of the things I like to do. I like to check Black's Law first if I don't know the term, and then if I still don't know the word, no reason to be too proud to look up a word at whatever age. So, yeah, I'm just double checking. I don't have purloin in this Black's Law, and it just didn't come up in a search. And just another second here, and we'll be almost done here looking through it. It's a scanned edition. That's one of the things with this. Makes it hard to do digitally, whereas if you have a paper one beside you, it's easier to do this kind of research typically, but then you don't get to do it with a great audience and get the feedback we have. All right, so I'm not finding purloin in here. Let's see. I'll finish this up along with you guys here. Oops. Let me get this back here. 1379. Come on, get there. What happened? Okay, a second here. Nope, didn't do the right page. Shoot. Come on. There. All right. Appreciate you guys sticking along for this. No, I don't see purloin here. Be around here. Okay. Sorry about that. Let's continue. Okay, convert or without authority. All right, let's read this again. Another federal statute. Purloin is just another way of saying theft. Thank you. I appreciate that. Great, guys. Yeah, sometimes a regular dictionary is great, and I got too much internet stuff going on the stream right now for me to break away to do something like a Google search. Might just interrupt the stream. All right, thanks, guys. Appreciate that. Let's continue. Another federal statute makes it a crime to knowingly embezzle, steal, purloin, convert, or without authority, sell any record, voucher, money, or thing of value of the United States, or any property made or being made under contract for the United States, or to receive, conceal, or retain it, knowing that it has been embezzled, stolen, purloined, or converted. Wow. Any record, voucher, money, or thing of value. So that's under a federal statute, and it involves records amongst other things. Yet another federal statute makes it a crime to feloniously steal, take away, alter, falsify, or otherwise avoid any record, writ, which would be the written judgment from a court, the process, or other proceeding in any court of the United States whereby any judgment is reversed, made void, or does not take effect. So this is interesting here. I want to focus on this one part. Yet another federal statute, and that'll be footnote 5. It makes it a crime to feloniously falsify or otherwise avoid any record. That's an interesting phrase. In any court of the United States, not just federal court, it says in any court of the United States. I'm not sure if they mean just federal courts when they say United States or not, but footnote 5, 18 U.S.C. 1506. We could look it up ourselves to find out. Federal statutes also prohibit officers or employees of the United States from knowingly compiling or issuing false statistics or information relating to products of the soil as a report of the United States, and prohibits officers, clerks, agents, or other employees from making false or fictitious entries in accounts or records of any kind with intent to deceive, mislead, injure, or defraud. So, circuit courts have wills and other voter registrations. All right, let's continue. In addition, it is also a federal offense for anyone to knowingly issue or publish any counterfeit weather forecast or warning of weather conditions falsely representing it to have been issued or published by the Weather Bureau, United States Signal Service, or other branch of the government service with a capital G. Interesting. To knowingly issue or publish any counterfeit weather forecast. A federal statute makes it unlawful for any person to make or submit any false record or account of any fish, wildlife, or plant that is intended to be imported, exported, transported, sold, purchased, or received from any foreign country, or transported in interstate or foreign commerce. So, look at this. I mean, how many people are aware of this? Do you know this? Do you know that it's unlawful for any person to make or submit any false record or account of fish, wildlife, plant that is intended to be imported, exported, transported, sold, purchased, or received from any foreign country, or transported in interstate or foreign commerce? So here, living in Florida, we have these spiny lobsters that come out, and they're federally protected. If you don't know this, and you take one and you send it across state lines, you're in violation of a federal statute. So it's if you take it across state lines, it's the same way. Is this purchased, sold, or purchased, received, transported, exported, imported? You import a spiny lobster from another country out of season into Florida, and you're going to be in violation of a federal statute. So that's under 9. That's probably another U.S. code. It is 16 U.S.C. 3372. I recommend you read this, Section D. It's probably going to be enlightening to you to see how these federal statutes, when someone tells you that only criminals plead the fifth, and you read some of these U.S. codes, you'll realize that perhaps it's best to plead the fifth until you're sure of what you're talking about. All right, let's continue. Now we get to state crimes for removal, destruction, or falsification of public record. So state statutes, so in your individual state, may provide criminal penalties for an offense of removing or destroying public records by the actions of unauthorized persons or tampering with public records, including the theft or destruction of public records, or fraudulent secreting of public records. So what's a secreting? I know what a secreting is, but let's see if Blacks has a different definition of that too. Yeah. Well, there's a moment here. It's used quite a bit, so I can get to the S's. Gosh, this thing's terrible at searching. Almost. Jeez. A lot of secrets in patent law that has to get passed. All right, we're close here. Set secret. Almost. Another thing that makes it really hard to search with this is that I don't have the headings on the top like you do with the paper one, which is how I like to search I-1501. Wow, a lot of secrets. Yeah, there are a lot of situations like that where we had destruction of evidence. But if you're not aware of these things, then how would you know to make a claim? Yeah, I don't see a secreted. Okay, so we get secret. So let's look at this carefully here. Secret, noun, 14th century. Something is kept from the knowledge of others. Information that cannot be disclosed. The client is requested to be kept private. The attorney believes under the ABA Code of Professional Responsibility. Okay, so I know there's some other definitions of this, but this is good enough for now. All right, let's return. Secreting of public records. So making them secret is what I believe this is saying. Okay. It is also generally a crime to offer a false or forged instrument to be filed, registered, or recorded in a public office. Although a falsification statute may be limited to acts by specified statutory officers. So only specified state officers can be charged with the crime generally in some states. Again, the reason that American jurisprudence is written like this is because we're looking at state crimes from a general perspective, and the general principles are going to apply across our nation. However, each state has their own statutes, and where there's no conflict with the Constitution, the supremacy of law, etc., then the state statutes will stand. All right, it's also generally a crime to offer a false or forged instrument to be filed, registered, or recorded in a public office. Although a falsification statute may be limited to acts specified by specified statutory state officers, it is a statutory violation of false alteration of governmental records for an officer to create a governmental record and write a false entry in it simultaneously. False alteration of governmental records for an officer to create a governmental record and write a false entry in it simultaneously. So if they're creating a record falsely at the beginning simultaneously, then it's a statutory violation of false alteration of governmental records. So there's another count. The procuring or offering of a false instrument for filing in a public office is an entirely separate offense from the falsification of a document that is already part of the public record. So we get that distinction here, right? One, you're creating a falsified record, and here you're altering one that's already part of the record. Providing false information on proof of service on the back of a subpoena, and later attempting to mislead a court into believing that the defendant has personally served a subpoena on a witness is sufficient to support a conviction for tampering with public records. That's footnote 9. Iowa, 1998, State versus Walker. Now that's an interesting case to look up. So anytime that you're seeing any kind of falsified records that are attempting to mislead a court into believing the defendant has personally served a subpoena on a witness. Wow. Okay, so we have some pretty interesting stuff here. Sufficient to support a conviction for tampering with public records. So this is something to keep on the lookout for and hold our public servants accountable. Here's an observation. A statute providing that every officer who has custody of a record deposited in any public office shall not steal, remove, secrete. Now that has an E at the end, and I believe that's more like secrete, not secret. And it may not necessarily be a legal term of secrete. Let's find out. You get past secretaries. Oops. Here we go. Secrete. No, we don't have it, do we? Oh, here's secrete. So, jeez. 17th century, to conceal or secretly transfer property, etc., especially to hinder or prevent officials or creditors from finding it. So it's a special way of secrete. Secrete. To conceal or secretly transfer, especially property, right? To hinder or prevent officials or creditors from finding it. Okay. Like money laundering. All right. Let's get back here. Statute providing that every officer who has custody of the record deposited in any public office shall not steal, remove, secretly transfer without the official notice, right? Destroy, mutilate, deface, alter, or falsify the record, or permit another person to do so, does not make it a crime for any person to steal, remove, or secrete official government documents. So, in other words, it's not a crime for any person to do it. If someone breaks in and does it, it would be something different. It's not the crime under the statute. It would have to be maybe under some other breaking and entry statute, maybe, but you wouldn't be able to get someone destroying public records if it's not their official government duty. It appears to be here, right? See, it's every officer who has custody of a record shall not do this. and may not permit another person to. So the only way they could be charged of a crime if they permitted another person to and they colluded with another person. Other than that, no, just because another person did it would not make the other person criminal under this statute. But of course, if you're destroying public records, you don't have any business being there. You're probably guilty of another crime. All right. Are we still online here? So a little notice coming up here, just making sure we're still all there. Yeah, if you guys could give me a 1 or something in the chat so I know I didn't lose the stream here. So we got public records within state laws regarding removal, destruction, or falsification. So, to be a public record within the meaning of the statute prohibiting the alteration, defacement, destruction, removal, or concealment of a public record, the official books, papers, or records must have been created, received, or used by the state or any agency of the state and kept, whether on a manual or automated basis, by the state or the governmental agency creating, receiving, or using them. Now, that's a mouthful, but it's very important. All right, guys, thanks. To be a public record within the meaning of the statute prohibiting the alteration, defacement. So we're looking at the meaning of it within a particular statute, and this is a statute, meaning your state statute, because it's not the same across all 50 states necessarily. So to be a public record within the meaning of a statute prohibiting the alteration, defacement, all these things, right? For it to be there, the official books, papers, or records must have been created, received, or used by the state of any agency of the state and kept, whether on a manual or automated basis. So this is pretty cool that they have to have been created or received or used by the state or any agency of the state, and kept by the state or governmental agency creating, receiving, or using them. So the custodian, the one doing it, is going to be the one that creates it, maintains it, either on a manual or automated basis, but they're responsible for it, and it becomes a public record within the meaning of that statute. So this is really defining a public record first, and then who's responsible for it, for doing these things or preventing these things from happening to it, and to keep it, which we also would call the preservation of the record. The fact that a form is not necessary does not negate its existence as a form kept by a governmental entity so as to constitute government record within the meaning of tampering with record statute. So let me give a distinction here, at least from my knowledge of this. A form document is a special kind of document. We have record documents. There's various kinds of documents that you may have, but a form document is usually a structured, I guess you could say a template in a way, but it's a structured way of collecting data to be brought into the record. So the form as it stands is something that doesn't contain content per se that's public record. It's just designed in a way to collect it in a structured way as to be in conformity with standards, statutes, policies, whatever might be necessary for the public record that's being created, if that makes sense. So the form, it may not be necessary. However, the fact that a form is not necessary does not mean that its existence as a form kept by government entity is to constitute a government record, meaning within that statute, meaning that even if the form doesn't contain critical content or information as public record, the fact that if that form is modified, the purpose of the form is to collect specific data for the record. And if that form is altered, then perhaps it could alter how that data is collected, alter the process and policies of that entity, that governmental entity. Therefore, it is protected under that statute from tampering, if that makes sense. Yep, and I think that we could all see our friend Audit Them has demonstrated this in person in a live audit where he went to the police and they were insisting on using a form, and he was able to cite the statute that specifically they cannot limit you to using their form, that they cannot require a standard form. But that now is an Illinois statute, and depending on where you are, your laws may differ. So the important thing is that in your state, you need to check your statutes to make sure that it applies to your particular situation, because again, this isn't something that that you will find consistently, because we're talking about state law now. Let's continue. Even a document not considered a public record under a Freedom of Information Act may fall within the protection of a statute proscribing tampering or destroying public records. So look at this. Even a document not considered a public record under a Freedom of Information Act may fall within the protection of a statute proscribing tampering or destroying public records. So document. What document could that be? Well, I don't know. We'd have to look at footnote 3, and you probably look into the case of this, footnote 3, which is Nero versus Highland, 1978, and that is New Jersey. And we'll find the answer there, because I don't want to speculate any further on that. But as you can see, the thing about American jurisprudence is that you get every angle of the law here in principle and in practice. You learn about state law, federal law, statutory construction, everything, constitutional law, and all of it is interrelated in such a way that there's no other legal system that approaches bringing a codified version of law better than American jurisprudence, in my opinion. And learning it is the best way of preserving it for us and for posterity. So I appreciate everyone that's here along with this. Let's continue. Documents that are not open to inspection by the public may not be public records within the meaning of statutes setting out to certain offenses relating to the misuse of public records. So there are certain documents that are not open to inspection by the public, and they may not be public records within the meaning of statute, so certain offenses relating to the misuse of public records. But there is authority holding that the fact, holding is a case holding, that the fact that a document is not open to general inspection by members of the public does not, in itself, mean the document is not a public record subject to such a statute. So it seems kind of confusing and misleading, but what this really means is that just because it's not open to inspection, it may not be viewed as a public record within the meaning of statutes for certain offenses, but that does not mean it is not a public record just because of that differentiation with certain meanings of certain statutes. So let's look here. By the latter view, the nature of a public record is not based on public availability, but on whether a public body prepares, owns, and retains the record. So see how well this is summed up here. And when you look at stuff like this, you can sum it up like this, and if someone wants to give you a little blurb, but the fact that we went on this journey of reading all the way up to this, breaking it down, reading every word, when we come up to a statement like this, if someone wants to question us on it or ask any detail, well, we're going to be able to really break it down for them ad nauseum until they say, all right, you're right. And not that you're right, but footnote 6 says you're right. This guy in State versus Nelson, 1993 in West Virginia, agrees with your interpretation because it came from him. These aren't our words. These aren't our ideas. this is by the latter view, the nature of a public record is not based on public availability. If someone claims that, oh, it's not publicly available, so it's not a public record. No, it's a public record because a public body, as defined by your statute, prepares, owns, and retains the record. Done. It's not based on its public availability. Okay, so let's continue. Make sure you have that number 7 Esquire pencil ready. The filing or other formal retention of a document by a public office makes that document a public record within the meaning of a statute prohibiting the forgery or other misuse of public records. And the documents that have not been filed or kept by a public office are not public records within the meaning of such a statute. So the filing or other formal retention of the document makes it a public record within the meaning of a statute prohibiting the forgery. So we're only looking at statutes talking about the crimes. Remember, that's the topic for tonight, the forgery or other misuse of public records, right? The forgery, alteration, destruction, secreting, etc. And documents that have not been filed or kept by a public office are not public records, right? Within the meaning of such a statute. So as you can see, we'll revisit these same concepts over and over again to really hammer them in, because chances are if you're opposing this in your adversary in court, will try to twist it around saying, oh, this is a public record or this isn't. And you need to be very firm once you have a clear understanding of this as based on established holdings. And you need to be able to affirm this time and time again, because you'll find adversaries, when they're wrong, will just keep digging themselves deeper in a hole, and you need to find a way to articulate it more ways than once, that each way has the same impact of the truth. All right, let's continue. The mere fact that a paper is found in a public office does not necessarily make that paper a public record within the meaning of such a statute. And that's footnote 9, and that is People versus Olson in 5th District, California. California Reporter, okay. Items constituting public records under these statutes include, all right, so let's look at some of the items constituting public records here. Look at this great checklist. A property tax record is a public record. Motor vehicle registration records. Now, if you don't think a property tax record is a public record, let's look at footnote 10. And here's your case law, People versus Cruz. That's in the 9th Circuit, 1995, Georgia law. 1995, okay, so that's something to look at. Motor vehicle registration records. Social Security card is a public record. A state bar admission record. Do you see this, people? This is a public record. A permanent residency card. A court order. A judge's warrant. An officer's offense report is a public record. An officer's accident report. A controlled substance test release form. A release bond. A firearms qualification form. Okay, notice form. A campaign finance report. We've heard of these. And I've seen an auditor that usually tries to find these. A detention facility incident report. A criminal history summary in police files. Criminal history summary in police files is a public record. Items not constituting public records include a fake Social Security card, a bid for garbage collecting franchise, a private academic transcript, private. A paper purporting to be a birth certificate is not a public record. A paper purporting to be a birth certificate, and did I see birth certificate on this one here? Is a birth certificate a public record? Did I see birth certificate? No. Interesting. This is odd. Now, it doesn't mean it's not. It just means we don't have a reference of case law or code that would corroborate that. I don't see it. Do you see it? Well, it is public record. But of course, items not constituting public records include a fake Social Security card. So if it's fake, no one's going to have to worry about that. But how would you know if it's fake if you can't compare it to the real one? See? So it's a double-edged sword, isn't it? If we can't compare it to the original public record, how do we know it's a fake? A bid, okay, a private academic. Now, a paper purporting to be a birth certificate. And purporting, usually we use things like this like synonyms of other words, but let's look it up exactly what it means in Black's. Purport. Jeez. Dutch lottery. Oh gosh. Hang on, I'm getting there. Well, it's one of those words that's in there so many times. 1384. Purport, 15th century. The idea or meaning that is conveyed or expressed, especially by a formal document. So it's an idea or meaning that's expressed by a document. So that's a public record. Would be something purported in it. This is what they're saying here, huh? Let's get back. Okay, a paper purporting, right, professing the claim to be a birth certificate. And paper purporting, I guess that's being a little bit redundant here, right? Because we're saying it's a document, right? Typically. Just a second here. I just noticed something. We have two different definitions here. 17th century one. Oh, geez. Okay, so we're looking at the idea or meaning as expressed by a formal document, but now I'm just realizing we have 17th century to profess or claim, especially falsely, to seem to be. Document purports to be a will, but it's neither. Okay, so there we go. How words change over the course of 200 years, huh? Very interesting here. All right. Yeah. So there it is. So this is another interesting thing here to see how words change over time. So before purport was just the idea or meaning that is conveyed or expressed, especially by a formal document. But now when something's purported, it is still the professor claim, but it's especially falsely. To seem to be. See how it's really kind of especially. The document purports to be a will, but is neither signed nor dated. Purported, reputed, rumored. So interesting way the words have kind of perverted over time in a way. And I wonder if on the first edition, if it's got this difference here. All right, well, there we go. Well, I digress, but it's a good thing to do these exercises because it's part of the journey is to stop along the way and get into the habit of looking up every word, because I truly believe no word should be left behind. All right, let's continue. So, a cash book that was blank before a false entry was made. I guess that's not a public record either, huh? Okay, and then see, we had a footnote for each of those particular instances. So, it's not just your opinion or you're reading it from a list, as in this book, saying a property tax record is a public record. You have basically case holdings here for each one of these specifically. And that's just what you're getting here. You could probably dig deeper and still, once you pull up this case holding, you're going to find references to others. So, in most cases. So, it's just a great journey when you're trying to really understand the law and not just go with a cookbook approach or going by people's opinions and hearsay, but you actually understand the functioning of every word, every law, and the way they interrelate. Because if you really want to know how I feel about this, is that some of the people that we hold with a public trust of executing their duties of the courts and of jurisprudence sometimes don't have as good of an education as they should, and that's just a reality of the times. And sometimes it's up to us to give the court officials, workers, fudges, etc., a chance to do what's right. And usually that involves educating them. So we're getting into the public records within state laws regarding removal, destruction, falsification, etc. But I know we're getting pretty long into this. I don't know if we could continue from section 15 on the next one, because I got to say this is that the public records laws are very long, and I can see doing many different episodes of this along the way. Of course, hitting other topics with American jurisprudence in between, but we can always be coming back to this because public records is so far-reaching. Essentially, records and documents is the way we can have evidence that the government is functioning the way it's supposed to. We could say that public records are there to show that the government does what it says and says what it does. And it's really the way that the public has its only tool available to ensure it's being done correctly. And then we can use the courts, once we have that evidence, to enforce the proper duties that are their responsibilities by their oaths. So on that note, I would like to continue from section 15 next time. We've gone over an hour here, so which is great, and I really appreciate everyone's attention this whole time. Again, this is a great journey that I'm going on with you, and I think that it behooves all of us, if we have any concern for posterity, to treasure our style of American jurisprudence by learning, understanding it, and requiring it anytime we have to go for any redress or any types of claims or have to defend ourselves in a court of law. So that being said, I appreciate again everyone's time for coming out. Please hit the like and subscribe so you can be alerted for future journeys we take here in reviewing American jurisprudence. And again, I want to thank everyone for coming, and I'll see you on the next one. Peace out.